My business partner cut me out of the company right before it sold. My name was still on the patent. "You signed it, Daniel," Marcus said, sliding the termination letter across the conference table like it was a lunch menu. "Read the fine print next time." I sat there staring at my own signature at the bottom of a page I didn't remember agreeing to. Outside the glass wall of that conference room, our engineers were still building the machine I had invented. The machine with my name stamped into the patent filing, in ink that couldn't be erased no matter how many lawyers Marcus hired. He thought a signature on a termination letter was the end of the story. He had no idea what was still sitting in a fireproof box in my garage. My name is Daniel Reyes. I'm 37 years old, a mechanical engineer living in Austin, Texas. Before you keep watching, hit that subscribe button and drop a comment letting me know where you're watching from tonight. I read every single one. This is a true story about the 2 years I spent building something with a man I called my brother, and the 11 months it took him to try to erase me from it. Stick around, because by the end of this, you'll understand exactly how a folder full of paper beat a company full of lawyers. Let me take you back to where it actually started, because you need to understand who Marcus Whitfield was to me before you can understand what he did. I met Marcus in a machine shop at Georgia Tech, back when we were both 22 and neither of us owned a car that started reliably. He was loud in a way that made people trust him immediately, the kind of loud that sounds like confidence instead of noise. I was quiet, the kind of quiet that made people assume I didn't have opinions, when really I just didn't waste them. We were paired on a senior design project building a torque-limiting coupling for a robotics competition, and something about the way we worked clicked. He talked to people. I talked to problems. Between the two of us, we finished a project that took most teams 2 semesters in 11 weeks. After graduation, we went our separate ways for almost a decade. He went into sales at an industrial equipment company in Charlotte. I went into product design, first at a mid-sized manufacturer in Ohio, then at a smaller firm in Austin that built components for oil field equipment. I got good at one very specific thing: designing valve assemblies that didn't fail under pressure differentials that killed other people's designs. Not glamorous, but precise. And precision, it turns out, is the kind of skill nobody notices until something breaks. In 2019, Marcus called me out of nowhere. "I've got an idea," he said, "and I need somebody who actually knows how to build things, not just talk about them." The idea was a modular pressure regulation valve for use in mobile hydraulic systems, construction equipment, agricultural machinery, that kind of thing. Cheaper to manufacture than the industry standard, faster to install, and built around a sealing mechanism I'd been sketching in notebooks for 3 years without ever having the capital or the reason to build it. Marcus had the reason. He had contacts. He had a cousin who ran a fabrication shop willing to give us cheap prototyping time. He had, most importantly, the kind of energy that convinces people to take a risk on something that doesn't exist yet. I had the design. We started Reyes Whitfield Fluid Systems out of a rented unit behind a tire shop on the east side of Austin. Not glamorous. I want you to picture it honestly. A space heater running through winter because the building's heat didn't reach the back unit. A coffee maker that Marcus insisted on buying used from a restaurant supply auction. 3 folding tables pushed together to make one long workbench. We split everything 50-50 on paper. 50% equity each. Marcus handled sales, contracts, relationships with distributors. I handled design, prototyping, and eventually, the patent. That's the part you need to remember, the patent. In March of 2020, I filed a provisional patent application for the sealing mechanism, the actual technical heart of the valve, the thing that made our product different from every other regulator on the market. My name was on it as sole inventor because I was the one who designed it, tested it, and refined it through 11 prototype iterations, most of them late at night while Marcus was out meeting distributors. That's not me diminishing his contribution. He built the business around the invention. But the invention itself was mine, on paper, permanently, in a filing with the United States Patent and Trademark Office dated March 14th, 2020. I kept every version of that design in a green 3-ring binder I'd had since grad school. Prototype sketches, material tolerance calculations, dated test logs from every failed seal, every burst valve, every version that almost worked before the one that finally did. I called it my build book, and it never left my possession. Every entry was handwritten, dated, and signed at the bottom of the page, a habit my old professor had beaten into me because handwritten, contemporaneous records hold up in a way that digital files edited 100 times never do. Marcus used to tease me about it. "You and that binder," he'd say, shaking his head, "like it's the Ark of the Covenant." I didn't know, yet, how right that joke would turn out to be. For the first year, things were good. Genuinely good. We landed our first distributor contract in the fall of 2020, a regional agricultural equipment supplier in Waco who ordered 400 units on a trial basis. Marcus took me out to celebrate at a steakhouse neither of us could really afford yet, and he raised his glass and said something I still remember word for word. 50-50, man, whatever happens, that was always the deal. I believed him. Why wouldn't I? We'd slept on the floor of that rental unit more nights than either of us wanted to admit, splitting a bag of gas station sunflower seeds because neither of us had drawn a paycheck in 4 months. You don't do that with someone you don't trust. By 2021, we'd grown to 14 employees and moved into a real facility off Burnett Road. Marcus brought on an investor, a private equity guy named Roland Ashby, who ran a small industrial fund out of Houston. Roland put in $600,000 for an 18% stake, which diluted Marcus and me down to 41% each. I remember signing that paperwork at a conference table that actually matched, in a building with a working thermostat, and thinking we'd made it. We had lawyers now. We had a real cap table. We had, for the first time, something worth protecting. I should have asked more questions about what protecting would come to mean. Here's the first betrayal, and I want you to notice how small it looks at the time, because that's how these things always start. Small, deniable, easy to let go. In June of 2021, Roland's fund brought in an operations consultant named Priya Nair to help streamline what she called IP governance. Basically, making sure all our patents, trademarks, and trade secrets were properly assigned to the company entity instead of sitting with individuals. Standard stuff, on its face. Investors want the company to own its own intellectual property outright. It protects their investment if a founder ever leaves. Priya drafted an IP assignment agreement that would formally transfer my patent rights from me personally to Reyes Whitfield Fluid Systems, LLC. In exchange, I'd receive a specific, documented equity adjustment, an extra 6% ownership stake, reflecting the value of the core patent I was contributing to the company. It was drafted, reviewed by outside counsel, and scheduled for signature at our next board meeting. Marcus was the one who sat down with me the night before that meeting. "Look," he said, leaning back in his chair with his hands behind his head, "Roland's people move fast. Just sign what Priya sends over. It's the same deal we already agreed to, just made official." I read it. I want to be clear about that. I did read it once at 11 at night, tired, trusting the man across the table from me who I'd built a company with. It said what Marcus said it said. Assignment of patent rights to the LLC, 6% equity adjustment in return, effective upon signature. I signed it. Marcus signed as CEO, accepting the assignment on the company's behalf. Roland signed as a witness on behalf of the fund. Except somewhere between that signature and the version filed with our corporate records 6 weeks later, the 6% equity adjustment clause was gone. Not amended, not renegotiated. Just quietly absent from the final executed copy that went into the company's official records. A copy that had somehow acquired an entirely different signature page, one that referenced prior discussions regarding compensation to be addressed separately, language that appeared nowhere in the draft I remembered reading. I didn't catch it for months. Why would I? I trusted the process. I trusted Marcus. And frankly, I was buried in engineering work. We were scaling production, dealing with a supplier defect that cost us our entire October shipment, working 80-hour weeks trying to keep the company alive. Corporate paperwork was Marcus's world, not mine. I signed what was put in front of me by people I had every reason to believe were acting in good faith. That's betrayal number 1. And here's the number that matters. 6% of a company that would eventually sell for $11 million is $660,000. Gone, quietly, in a clause that disappeared between a Tuesday and a Thursday. I didn't know that yet. Nobody tells you the size of the wound while it's still healing wrong. Let me tell you about my wife, Elena, because she's the one who first noticed something was off, months before I let myself see it. Elena and I had been married 6 years by this point. She worked as a labor and delivery nurse at St. David's, which meant she came home from 12-hour shifts holding other people's most fragile moments and still had the patience to sit at our kitchen table and listen to me talk about seal tolerances and distributor contracts. She has this quality, I don't know how else to describe it, where she can hear the same story you've told her 20 times and still catch the one word that's different this time. In February of 2022, I came home frustrated because Marcus had, for the 3rd month in a row, delayed sending me the updated financial statements he'd promised the board he'd distribute monthly. He says Priya's still finalizing them, I told Elena, pulling a beer out of the fridge. Same thing he said in December. Elena was chopping vegetables at the counter, not even looking up. Why do you need his permission to see your own company's financials? I didn't have a good answer. I told her it was just Marcus being disorganized, that he'd always been better with people than paperwork, that I'd rather spend my energy on engineering problems I could actually solve. Daniel, she put the knife down, you design the thing the whole company is built on. You should know exactly where every dollar of it is going. I brushed it off that night. I want to be honest with you about that, because this isn't a story about a man who saw everything coming. I missed things. I explained away things. I trusted a friendship that had survived a decade and a shared space heater, and I assumed that friendship was load-bearing enough to hold whatever weight got put on it. It wasn't. Betrayal number 2 came in April of 2022, and this one I actually witnessed, though I didn't understand what I was seeing until much later. Roland's fund wanted to bring in a new chief operating officer, someone with scale-up experience, which is private equity language for someone who knows how to make a company look attractive to a buyer. Marcus championed the hire enthusiastically. Her name was Kendra Voss, and she came in sharp, competent, and immediately began restructuring reporting lines so that engineering, my department, reported to operations instead of directly to the CEO and board. On paper, this sounded reasonable. In practice, it meant every decision I made, every design change, every prototype approval now had to route through Kendra before it reached Marcus or the board. And Kendra, it turned out, had one very specific mandate from Roland: make the company sale-ready within 18 months. I didn't think much of the reporting change at the time. I was an engineer. I wanted to build things, not manage org charts. What I didn't realize was that this restructuring quietly reduced my visibility into the company's strategic direction at exactly the moment strategic decisions were being made about my future in it. In May, Kendra called me into her office. a small, glass-walled room that used to be a supply closet before we moved into the Burnett Road building, and told me, almost as an afterthought, that going forward my role would be reclassified from co-founder and chief engineer to senior design consultant. "It's a title thing," she said, not quite meeting my eyes. "Doesn't change your comp, doesn't change your equity. Just cleaner for the cap table ahead of any future transaction." I asked Marcus about it that afternoon. "It's nothing, man," he said, clapping me on the shoulder in the hallway. "Roland's people are obsessed with titles. You're still you. Nothing's changing." I want you to sit with that phrase for a second. Nothing's changing. Because in my experience, when someone tells you nothing is changing while everything around you is being quietly restructured, that phrase isn't reassurance. It's cover. Here's the object I need you to remember, because it's going to matter more than anything else in this story. Sometime around this same period, late May of 2022, I started keeping a second set of notes, separate from my green build book. Not because I suspected Marcus specifically. I want to be honest about my own state of mind at the time. I wasn't thinking my business partner is stealing my company. I was thinking, something about this restructuring feels wrong, and I don't understand corporate law well enough to know if it matters. So I started a folder, a literal manila folder, then later a corresponding digital archive, where I saved every email, every signed document, every meeting note that touched my equity, my patent, or my role at the company. I called it, in my own head, the provenance folder. Every patent draft with its date-stamped revision history. Every email from Priya about IP assignment. Every text from Marcus about the same deal we always had. Every version of every contract I'd ever signed, cross-referenced against what actually ended up in the company's official corporate records. I didn't build that folder to protect myself from Marcus. I built it because 12 years of engineering discipline taught me that when something doesn't add up, you document everything until it does. That folder would end up being the reason I won. But I'm getting ahead of the story, and you deserve to feel every step of this the way I felt it, one confusing, painful piece at a time. If you're finding this story compelling so far, drop the word patent in the comments so I know you're still with me, and hit subscribe if you haven't already. There's a lot more coming, and I promise the ending is worth staying for. Now, back to 2022. Betrayal number 3 arrived in August, and this is the one where I stopped being able to pretend everything was fine. Roland's fund initiated formal conversations with a strategic acquirer, a much larger industrial manufacturer based in Dallas called Cortland Hydraulics, a company roughly 40 times our size that wanted to add our patented sealing technology to their existing product line. The acquisition talks were, at this stage, supposed to be confidential, restricted to the board and senior leadership. I found out about them from a supplier. Tom Ackhaffer, who ran the CNC machining shop we used for prototype components, mentioned it to me casually over lunch. "Heard you guys are talking to Cortland," he said. "My buddy does contract work for them. Said their engineering team's already been asking around about compatibility with our tooling." I sat there with a burger going cold in front of me, doing math that didn't work. If Cortland's engineering team was already asking about tooling compatibility, the talks were significantly further along than early conversations, which is the phrase Marcus had used the one time he'd mentioned it to me at all, 3 weeks earlier, in a hallway, in passing. I confronted him that evening. Not angrily, that's not really who I am, but directly. "How far along are the Cortland talks?" Marcus didn't quite look at me. "It's preliminary. Roland wanted to keep the circle small until there's something concrete to share." "I'm a co-founder, Marcus. I'm not the circle. I'm the thing being sold." He laughed, but it wasn't a real laugh. "Nobody's selling you, man. Come on." I let it go that night because I didn't have proof of anything except a lunch conversation with a machinist. But something in me had shifted. I started saving things more deliberately. Every email, every calendar invite I wasn't included on that I heard about secondhand. Every conversation where Marcus's answers felt rehearsed instead of honest. Betrayal number 4 hit in October, and it's the one that finally brought Alina fully into the story, because it happened at our house. Marcus and his wife, Denise, came over for dinner. Something we still did occasionally, a leftover ritual from when our friendship had been the whole foundation of the company, rather than something layered on top of a business relationship that was quietly rotting. Over dinner, half a glass of wine into the evening, Denise mentioned that they'd started looking at properties in Aspen. Vacation place, or? Alina asked, refilling water glasses. Honestly, Denise said, depends how the Cortland thing goes. Marcus thinks it could close by spring. The table went quiet, in a way that had nothing to do with the food. Marcus tried to recover it. Denise, we don't know anything yet. But I watched his face, and I want to tell you something about reading people you've known for 15 years. You don't need them to say the true thing out loud. You just need one unguarded sentence from someone who doesn't know they're supposed to be careful. After they left, Alina sat across from me at the kitchen table, the same table where she'd first told me to ask questions 8 months earlier. He's planning around a sale he hasn't told you the terms of, she said. Daniel, that's not disorganization. That's a decision. I didn't sleep much that night. Not because I was certain of anything. I still didn't have proof. Not really. Just a wine-loosened comment from a woman who wasn't even part of the company. But something had cracked open that I couldn't seal back up. I went out to the garage after Alina fell asleep and pulled the green billed book off the shelf where it had lived, undisturbed, for 2.5 years. I sat on an overturned bucket under a single work light and read through every page, start to finish, for the first time since I'd filled it. Every date, every signature, every failed prototype that led to the one that worked. I put it back in the fireproof box where it belonged, and for the first time, I made sure I knew exactly where every copy of that patent's provenance existed. The original filing, the assignment agreement, the emails, all of it, cross-referenced in the provenance folder I'd been building since May. I didn't know, yet, that I was about to need every page of it. Betrayal number 5 came in December, 3 days before Christmas, delivered the way these things always seem to be delivered. Casually, at the end of a normal conversation, like an afterthought instead of the sentence it actually was. Marcus called me into his office. Kendra was already there, sitting slightly behind him, which I noticed but didn't yet understand the significance of. Cortland's moving forward, Marcus said. Letter of intent, formal diligence starting in January. This is really happening, Daniel. For one moment, one genuine, unguarded moment, I felt the old excitement. The thing we'd built in a rented unit behind a tire shop was about to become real in a way neither of us could have imagined at 22 years old, sketching torque couplings in a machine shop. That's incredible, I said, and I meant it. It is, Marcus said. Then he glanced at Kendra, and something in his posture changed, squared up, rehearsed. There's something we need to talk through, though. Diligence is going to look hard at organizational structure. Cortland's counsel flagged some concerns about redundant technical leadership. Given that I'm CEO and you're currently classified as design consultant, they want a cleaner reporting structure before signing. What does that mean, practically? Kendra answered this time. It means your consulting agreement would be restructured. Full compensation through the closing, full recognition in all public materials as the original inventor. But your day-to-day operational role would wind down over the next 60 days, effective immediately as of today's date, December 22nd. I sat there in a room decorated with a small plastic Christmas tree someone had put on the reception desk, and I understood, finally, completely, What had been happening since that first 6% clause disappeared 18 months earlier? "You're firing me," I said. 3 days before Christmas, right before the company I invented gets sold. "Nobody's using that word," Marcus said. "Then what word are you using?" He didn't answer that. Nobody in that room answered that. If you've ever had someone smile at you while taking something away, you know exactly the silence I'm describing. It doesn't sound like conflict. It sounds like a closing door being oiled so quietly you don't hear it latch until you're already on the wrong side of it. I want to tell you about the one person who kept me from doing something reckless that week, because every story like this needs someone who sees clearly when you can't. Her name is Josephine Kwan, and she was our outside patent counsel, the attorney who had actually filed my original application back in 2020, before Roland's Fund existed, before Priya, before any of it. I called her that same night, December 22nd, standing in my garage with the phone against my ear and the fireproof box open on the workbench in front of me. "Send me everything," Josephine said, once I'd finished explaining. "Every version of every document dated in order. Don't sign anything else until I've seen it." 2 days later, she called me back, and she said the sentence that I would carry with me through everything that came after. The sentence I'd hear again at the very end of this story. "Daniel," she said, "paper doesn't forget, people do, but paper doesn't forget." I didn't fully understand yet how true that sentence was going to turn out to be. I just knew, holding that green build book in my hands, that I had spent 2.5 years accidentally building the one thing Marcus couldn't restructure me out of. Christmas came and went. I sat through it hollowed out, going through motions with my in-laws, smiling in photographs I don't remember posing for. Elena held my hand under the table more than once and didn't ask me to talk about it until I was ready. January arrived, and with it, Cortland's due diligence team and a version of Marcus I hadn't seen since our earliest days. The version that stopped pretending to be my friend and started treating me, openly now, as a liability to be managed. He called me in on January 9th. Kendra wasn't in the room this time. Just Marcus and a termination letter and my own signature waiting at the bottom of a page. "You signed it, Daniel," he said, sliding it across the table. "Read the fine print next time." He thought that was the end of it. He had no idea that 3 days earlier, Josephine had finished cross-referencing every document in my provenance folder against the company's official corporate records, and found 4 discrepancies that shouldn't have existed if everything had been done the way I'd been told it was done. She hadn't told me what they were yet. She wanted to be certain first. I was about to find out, and so was Marcus. Marcus had just slid a termination letter across the table at me, 3 weeks before Cortland Hydraulics was set to close its acquisition of the company I'd invented. And he had no idea my patent attorney had already found 4 discrepancies buried in our corporate records. I signed nothing else that day. I stood up, shook his hand because some habits die slower than friendships do, and walked out to my truck in the parking lot off Burnett Road, the same lot where I used to park at 6 in the morning during our earliest, hungriest years, back when this had been 2 guys and a folding table and a shared belief that we were building something worth the sacrifice. I called Josephine from that parking lot before I'd even started the engine. "Tell me what you found," I said. "Not on the phone," she said. "Come to my office, tonight if you can." I drove straight there. Elena met me, having left work early once I'd texted her 4 words. "He did it today," that she understood immediately, because we'd been living inside the slow approach of this moment for almost a year. Josephine Kwan's office was small, tucked into a converted house near downtown that she shared with 2 other solo attorneys. She had my entire provenance folder printed and spread across a conference table that was really just a repurposed dining table, organized into 4 stacks with yellow sticky notes marking each one. "Sit down," she said. "I want to walk you through this in order because the order is what makes it damning." The first stack was the original patent filing from March 2020. "This is clean," she said. "You're listed as sole inventor. No ambiguity, no shared inventorship claims, nothing Marcus or anyone else can contest. This document alone establishes that you conceived and reduced to practice the sealing mechanism at the center of this company's entire value." The second stack was the IP assignment agreement from June 2021, the one I'd signed at 11 at night, trusting Marcus's summary of it. "Here's discrepancy 1, Josephine said, laying 2 versions side by side. "This is the draft you were emailed 48 hours before signing. 6% equity adjustment, explicitly tied to patent assignment, contingent on nothing else. And this," she tapped the second page, "is the version filed in the company's official corporate records 6 weeks later. Same date on the signature page. Different clause. The equity adjustment isn't amended. It's gone, replaced with language deferring compensation to a future agreement that, as far as I can find, was never drafted." "How is that legal?" "It isn't necessarily. Someone altered an executed document after signature or substituted a new signature page and represented it as the original. Either way, it's not something that happens by accident." The third stack was Kendra Voss's org restructuring memo from May 2022, the one that reclassified me from chief engineer to senior design consultant. "This one's more subtle," Josephine said, "but it matters for a different reason. Look at the effective date." I looked, May 3rd, 2022. "Now look at this." She pulled a document from a folder I didn't recognize, something she'd apparently requested directly from the Texas Secretary of State's Corporate Filings Office. "This is Reyes Whitfield's board resolution authorizing preliminary strategic acquisition discussions with Cortland Hydraulics, filed April 26th, 1 week before your title change." So they restructured my role a week after deciding to sell the company, and before telling me the sale conversations existed. That's what the paper says, yes. The fourth stack was the one that made my stomach drop the way it hadn't dropped through any of the others, because this was the stack that showed intent, not just carelessness. "This is an email chain between Marcus and Roland Ashby," Josephine said. "December 14th of last year, 8 days before your termination meeting. I obtained it through a document Marcus's own assistant accidentally CC'd to a shared vendor account you still had access to, which then auto-forwarded to an old company distribution list you were still on. It's not something I asked for. It landed in your archived email, and you forwarded it to me back in November without either of us realizing what it was at the time." She read a portion of it aloud. Marcus, writing to Roland, "Cortland's diligence team will want clean cap table optics before signing. Recommend we finalize Daniel's consulting transition before their engineering team does a deep dive on inventorship. Once IP assignment is on record, his operational exit is just a formality, doesn't affect the patent, doesn't affect the deal." I read it twice myself, my hands not quite steady. "He knew," I said. "He knew this whole time that cutting me out operationally wouldn't touch the patent, because the patent was never his to touch. He just didn't think I'd ever look closely enough to understand what that meant." "He's right that removing you operationally doesn't strip your inventorship," Josephine said. "Federal patent law doesn't work that way. You are the named inventor of record. No corporate reshuffling changes that unless you sign something specifically assigning those rights. And the only assignment document that exists is the one with the altered compensation clause, which means the entire assignment is voidable for fraud in the inducement." I sat back in that borrowed dining chair, and something that had been a tight fist in my chest since December 22nd finally, slightly, released. "What does that mean for me, practically? Josephine set down her pen. It means Cortland cannot close a clean acquisition of that patent without your cooperation, your signature, or a court resolving the dispute. And courts do not move at the speed acquisitions need to move. It means you have leverage you didn't know you had, because you kept a green binder and a manila folder while everyone around you assumed paperwork was beneath you. Elena reached over and took my hand under the table, the same way she had on Christmas. So what do I do with it? I asked. You do exactly what you're good at, Josephine said. You don't panic. You don't call Marcus and scream at him, which I suspect isn't your instinct anyway. You let me draft a formal notice to the company's board, Marcus, Roland, and the 2 independent directors, laying out the assignment defect and putting them on notice that any acquisition proceeding without resolving inventorship rights exposes Cortland to significant future litigation risk. We give them a chance to fix this the right way before we make it anyone else's problem. And if they don't take it, then we make it Cortland's problem directly, and Cortland will make it Marcus's problem, because acquirers do not tolerate diligent surprises. Either way, Daniel, you're no longer the person without leverage in this relationship. You may not have felt like it these last few weeks, but you haven't been, not since March of 2020. I didn't sleep well that night, but for the first time in months, it wasn't dread keeping me awake. It was something closer to readiness. If you've made it this far, drop the word ledger in the comments, because that folder is about to become the whole story. And if you haven't subscribed yet, now's the moment, because what happens in that boardroom is worth staying for. Josephine sent the formal notice on January 16th. She didn't send it to Marcus alone. She sent it to the full board, copying Roland Ashby directly, along with the 2 independent directors Roland's fund had installed the year before, a retired manufacturing executive named Walter Ibsen, and a corporate finance advisor named Grace Tanaka, neither of whom I'd had much contact with beyond quarterly board meetings. The letter was 4 pages. It didn't accuse anyone of anything in the way a raised voice accuses. It simply laid out facts in order with exhibits attached. The original patent filing, the 2 versions of the assignment agreement side by side, the corporate resolution dated a week before my title change, and a formal legal opinion that the assignment agreement was voidable due to a material and undisclosed alteration of consideration terms. It requested one thing, that the board pause any further steps toward closing with Cortland Hydraulics until the inventorship and assignment issue was formally resolved with my full participation and consent. I heard nothing for 6 days. 6 days of going to a company I no longer had access to, sitting in my garage instead, running diagnostic simulations on valve designs that no longer belonged to anyone but me, waiting. On day 7, Grace Tanaka called me directly. Not Marcus, not Roland, Grace. Daniel, she said, I want you to know that Walter and I only received the full picture of this situation 6 days ago. We were not aware of the discrepancy in the June 2021 assignment agreement, and frankly, we're troubled by it. I appreciate you saying that. I'm not calling to apologize on behalf of the board, she said. I'm calling because we've scheduled an emergency board meeting for this Thursday, and legal counsel has advised that you should attend, given the exhibits attached to your attorney's letter directly implicate the validity of assets central to the pending transaction. Will Marcus be there? Yes, so will Roland. So will Cortland's general counsel, who requested to observe once we informed them a diligence issue had surfaced. I felt something settle in my chest, cold and clear. Not anger, exactly. Something closer to the feeling I get right before I run a final stress test on a design I've spent months refining. Not fear that it will fail, but a quiet certainty that I have already done the work to know whether it will hold. Thursday came. I want to describe that room to you carefully, because I've relived it more times than any other moment in this story. It was the same conference room where Marcus had slid the termination letter across the table 3 weeks earlier. Same glass wall overlooking the same production floor where our engineers were still building the valve I designed. Roland sat at the head of the table this time instead of Marcus, flanked by Walter Ibsen and Grace Tanaka. Marcus sat across from me, Kendra beside him. Cortland's general counsel, a woman named Renata Osai, sat slightly apart, a laptop open in front of her taking notes. Josephine sat beside me. I had my green build book on the table, along with a printed, tabbed copy of everything in the provenance folder. Roland opened the meeting. We're here because a legitimate question has been raised about the validity of the IP assignment underlying this acquisition. Daniel, your counsel has laid out the exhibits. I'd like to hear directly from you what you believe happened. I hadn't planned a speech. I'd planned exhibits in order, one at a time, the same discipline I use in any technical presentation. In June of 2021, I said, I signed an IP assignment agreement transferring my patent rights to this company in exchange for a documented 6% equity adjustment. Here's the draft I reviewed and agreed to. I slid it across the table. And here's the version that was actually filed in the company's official corporate records 6 weeks later. I slid the second page beside it. The equity adjustment clause is gone. I never agreed to that version. I never signed that version. Someone replaced a signature page and represented an altered document as my binding agreement. Marcus started to speak. Daniel, there was an ongoing conversation about restructuring the comp package, and there's no email, text, or meeting note referencing that conversation anywhere in the company's records, I said, sliding a third document across. A summary Josephine had prepared cross-referencing every communication touching my equity between June 2021 and December 2022. I checked. My attorney checked. If that conversation happened, it happened somewhere that left no trace, which is its own kind of answer. Kendra shifted in her seat, but said nothing. I continued, laying each piece down the way you'd present findings from a failure analysis, because that's exactly what it was. In April of 2022, the board authorized preliminary acquisition discussions with Cortland. 1 week later, my operational title was changed from chief engineer to senior design consultant, a change I was told was purely administrative. Here's the corporate resolution. Here's the restructuring memo. The dates speak for themselves. Renata Osai, Cortland's counsel, had stopped typing entirely. And here, I said, sliding the final document across, is an email from Marcus to Roland dated December 14th, stating explicitly that finalizing my consulting transition before Cortland's engineering team reviewed inventorship records was a strategic priority. Because, and I'm reading directly, once IP assignment is on record, his operational exit is just a formality. The room was very quiet. I looked at Marcus, and for the first time since that dinner at the steakhouse 3 years earlier, I saw something on his face that wasn't performance. It was closer to a man watching a version of events he'd told himself repeatedly finally fail to survive contact with the actual record. Daniel, he said, quieter now, I never wanted it to look like this. I believe that, I said, and I meant it, because I don't think Marcus woke up one day and decided to become a person who altered signature pages. I think he wanted the deal to close so badly, and told himself so many small justifications along the way, that by December he'd convinced himself the ends had earned the means. That doesn't make it right, but it makes it human, and I wasn't in that room to punish a man. I was in that room to protect something that was mine. I built the 50-50 partnership we started with, I said. I never stopped believing in it. You're the one who stopped believing you needed to keep it. Roland cleared his throat. Renata, I imagine Cortland has thoughts. Renata closed her laptop. Cortland cannot close on an acquisition where inventorship of the core patent is legally contested. This changes our diligence timeline significantly, and frankly, it raises questions about representations made to us throughout this process that we'll need to review internally before proceeding further in any capacity. Roland's face went the color of old concrete. Walter Ibsen, who had said nothing until this point, finally spoke. I'd like the record to reflect that as an independent director, I was not made aware of this assignment discrepancy at any point prior to Mr. Reyes' counsel's letter. I don't believe the board acted with full information, and I think that needs to be corrected before we discuss anything else. Marcus didn't say much else that day. There was no dramatic confession, no scene where he broke down and admitted everything on the record. That only happens in movies. What happened instead was quieter and, honestly, more believable. A series of careful, lawyer-guided non-answers, a meeting that ended without resolution, and a follow-up call scheduled for the following week to discuss remediation, which is corporate language for we got caught, and now we have to figure out how much it costs us. I didn't feel triumphant walking out of that room. I felt tired, in the specific way you feel after finally setting down something heavy you'd been carrying without realizing how much it weighed. Negotiations took another 6 weeks. I want to be honest with you about how unglamorous that part was, because I know some of you are expecting a single dramatic moment where everything resolves. It didn't work that way. It worked the way most real resolutions work. Slowly, through lawyers, through documents, through a process that felt less like victory and more like careful dismantling of a structure that had been built to exclude me. Here's what ultimately happened, laid out plainly. Josephine and I negotiated a corrected IP assignment agreement, one reflecting the actual terms I'd originally agreed to, plus additional compensation for the 18 months during which the fraudulent version had been in effect, plus a negotiated increase reflecting my direct contribution to closing the technical diligence gap that had stalled the Cortland deal for 6 weeks. In total, the corrected settlement restored my ownership position to a level equivalent to roughly 14% of the eventual sale price, considerably more than the 6% I'd originally been shorted, because Josephine's read of the situation was correct. Once fraud enters a negotiation, the person who committed it loses most of their leverage to argue about numbers. Cortland ultimately did complete the acquisition, 3 months later than originally planned, in April of 2023, for a final purchase price of $11.2 million. My corrected settlement came to just over $1.5 million, paid out over the closing and an 18-month earn-out period during which Cortland's engineering team, ironically, hired me directly as a technical consultant to help integrate the valve technology into their existing product lines. A role I only accepted because Renata Osai, during one of our later calls, told me plainly that Cortland valued engineers who documented their own work honestly more than they valued executives who didn't. Marcus's outcome was different. Roland's fund, embarrassed by the diligence failure and unwilling to be associated publicly with a fraud allegation during an active acquisition, negotiated Marcus out of his CEO role as a condition of Cortland proceeding with the deal at all. He retained his equity stake. Nobody accused him of a crime, and nothing in what happened rose to the level of criminal fraud charges Josephine, and I seriously pursued, largely because pursuing that route would have delayed my own settlement by years. And I decided, after a long conversation with Alina at that same kitchen table, that I valued getting my life back more than I valued watching Marcus suffer publicly for it. But he left the company we'd built together with a fraction of the reputation, and none of the operational role he'd spent 3 years maneuvering to consolidate. I saw him once more, at a mediation session in March, the two of us sitting across a much smaller table than the one in that conference room, lawyers on both sides, the fight mostly finished by then. "For what it's worth," he said, as we were both gathering our things at the end, "I am sorry, not for the outcome, for how I got there." I didn't forgive him in that room, and I want to be honest with you about that, because I think there's a version of this story where I'd tell you everything wrapped up neatly, where Marcus and I hugged it out and became business partners again. That's not what happened, and I don't think that's what should happen when someone alters a legal document to take something from you. I hope you build something you're proud of, I told him, with people who don't have to check whether your signature page matches the draft you sent them. That's the last real conversation we've had. We're not enemies. We're not friends. We're two men who built something together and discovered, painfully, that trust without verification is just hope wearing a suit. Here's where I want to bring this back to something Josephine said to me that night in her office, back in December, holding my green build book in her hands like it was something precious. Paper doesn't forget, she told me. People do, but paper doesn't forget. I think about that sentence more than almost anything else from this whole experience. Because the truth is, Marcus wasn't lying to me about everything. He was lying to himself first, telling himself smaller and smaller lies about what he deserved and what he'd earned, until eventually those lies needed my signature to become real. People do that. People convince themselves of almost anything, given enough time and enough motivation. But the documents didn't convince themselves of anything. The patent filing didn't care what Marcus needed to be true. The dated pages in my build book didn't care whose name was more convenient on a cap table. They just sat there, quiet and stubborn, exactly as true in January of 2023 as they'd been in March of 2020, waiting for someone to finally read them carefully enough to matter. If there's one thing I hope you take from tonight, it's this. Whatever you build, whatever skill you have, whatever thing only you know how to do, document it. Not because you expect betrayal. I didn't expect it either. Document it because the people who love you can only fight as hard for you as the evidence allows them to, and because trust, real trust, isn't undermined by keeping good records. It's protected by them. Today, I run a small engineering consultancy out of a proper office, not a converted tire shop, though I'll admit I kept the same folding table from those early days, refinished and sitting in the corner of my new workspace as something closer to a monument than furniture. Elena and I used part of the settlement to pay off our house outright and put the rest toward a fund we started for engineering students who can't afford the tools and testing equipment their programs require, but don't provide. The kind of resource neither Marcus nor I had at 22, sketching torque couplings in a machine shop that smelled like cutting oil and instant coffee. I still talk to Josephine regularly. Every new client contract I sign, every new patent I file, I hear her voice in my head before I put pen to paper. Read it twice, keep every version, date every page. Paper doesn't forget. People do. But if you keep the paper, it doesn't matter how many people try to. If this story meant something to you tonight, tell me in the comments. What's one thing in your own life, your own work, your own relationships, that you've never bothered to write down because you trusted the person on the other side of it? I'd genuinely like to know. Comment the word signature. If you made it all the way to the end, share this with someone who's ever been the quiet one in a partnership like mine, and subscribe for the next story, because this won't be the last time someone thought a piece of paper was the end of things, when really, it was only ever the beginning of the proof.